I'd like to call to order the City of Oak Harbor Planning Commission regular meeting on November 22nd, 2016. Let the record show that everyone's present except Councilman Melissa Merriman. Second item on the agenda, approval of the minutes of the regular meeting and the special business meeting. Do I have a motion?
I'll make a motion to approve the minutes as printed.
You have to specify the two dates, please.
I'll make the motion for to approve the October 25th, 2016 regular business meeting and the November 9th, 2016 special meeting.
We
as
have a
written.
motion.
I second.
All in favor?
Aye.
Aye.
I hate to do this, but I will, it's aye for the regular meeting. For the special meeting, I abstain because I wasn't there.
Okay. Okay, very good. Okay, the motion's passed. Item 3, like we do at every meeting, we're asking for public comment for items not otherwise on the agenda, and we allow the first 15 minutes of our planning commission meeting for this purpose. Do I have any takers? Seeing none, I close that part of our meeting. Item number 4, we have 2 public meetings this evening. The first one is the sign code public meeting. Staff will continue to brief the Planning Commission on proposed changes to the sign code.
Make sure I don't break this thing off, 'cause
Okay.
it's apparently fragile. Thank you, Commissioners. We are here to continue the discussion from the previous meeting regarding our sign code potential changes here. And so I'm going to go through a little presentation, discuss some of the work that I've been doing, and I encourage and ask that if you do have any questions or anything to let me know. And this is kind of a discussion. I want to find out if I'm missing anything or if I'm forgetting anything or if I'm making contradictions, et cetera, and things like that. So this is still early stages of the discussion. My plan here is to kind of bounce this off of you guys, come up with some concrete graphics and ideas and the matrix that we discussed last time, and then go out into the community and start talking to some of the stakeholders, presenting our ideas here, and getting a little bit more solid concept of what it is we're doing. So I'll go through this presentation. I'm going to talk a little bit about what we discussed previously, just kind of refresher. The content-based regulation is kind of what we're attacking here. We can't do that anymore because of what the Supreme Court has determined as far as the concept of strict scrutiny. The way that that's defined and everything we discussed before, so I won't bore you with all that, those details, the nitty-gritty, and getting into the weeds again. But to kind of go back to what we discussed previously, the form-based sign code. We're thinking that this is a new concept. This is kind of based on the idea of form-based zoning. We're looking at the sign itself, not what the sign says, what it's made of, where it's located, things like that. Justice Alito talked about a non-exhaustive list of some rules that might not be content-based, and they talk about sign size, location, lighting, fixed versus change messages, public and private property, and commercial versus residential property. So those are some of the things that we're going to focus on when we come up with these different sign types. As an important note, we're not looking to radically change the sign code. The number and the size of the signs is not going to change significantly unless we decide that there is a need for that. As I have it in my mind now and as I'm proposing, we're going to move forward with the exact same signs, just describing them in a different way. Content will not be a determining factor on how the signs are classified and regulated. That's the key thing here. So the focus tonight is going to be on temporary signs in Oak Harbor. Here are some examples of temporary signs you might see in Oak Harbor in graphical format. And so this is kind of what you're going to start seeing is pictures of signs. What is this sign and how do we describe it? So the form-based sign code is based on a graphical expression of the sign types combined with the matrix providing the regulatory information. You'll see the graphical expression is in much larger text there. That's what we're going to talk about right now. Okay, so the questions I have for us tonight. What types of signs exist in the code now? Are there any that need to be added? Should some sign types be consolidated based on size, location, or timing similarities? So those are some things to think about as we go through this, okay? What types of signs exist in the code now? Well, we have a definitions section in 1936-020. I'm not going to read through them. There's a whole bunch of different definitions of what signs are, and it gets into the weeds, and it's important to have those things in there, but we don't want to define the signs based on their content, which is what a lot of these definitions do. And so OHMC 1936-080 discusses the many differing types of temporary and special signs, again, focusing on temporary signs this evening. So you have construction signs, general promotional signs, light pole banners, grand openings and anniversaries, the various different real estate signs, portable A-frames, political headquarters, free speech and campaign signs, etc. And you notice a lot of those categories are based on what the sign says. So immediately we have an issue right there. So instead, we take what we call, quote unquote,
Sorry, can I chime in just real quickly on
Yes.
that? I tried to be quiet. I failed. And I know that the Planning Commission understands this, but I think it's worth saying on the record. When Ray says that we looked at what the sign said in order to figure something out, or how we regulated that, I want to be really clear. You don't look at the actual message under the old code, right? So it didn't matter whether it was company A or company B. That's not what we were looking at, or political candidate A or candidate B. It was the type of message, and that's how you identified the type of sign that we were dealing with. So just a clarification, but I think an important one, that we never were actually regulating based on what the sign said itself.
Important, yes, I agree. So we have here our quote-unquote construction sign, which is found in the code. Okay, so it's 32 square feet. It's got a maximum height of 10 feet. There are similar signs that you can use for condominiums, apartments, and mobile home parks that are for sale or lease, or a residential land subdivision, or political free speech and campaign signs not at a headquarters. So you can see that we have a sign here that is used in multiple different ways, but all of those regulations are based on what is on the sign itself, what it's saying. And so again, that's the issue. So if we take a look at that sign and describe what the sign itself is, a 4 by 8 foot piece of plywood or other type of material that's installed on posts that are less than 10 feet in height, this is how we can describe the sign and thereby regulate it in that manner instead of regulating it by what the sign is conveying to you, what message it's saying. So we have two different types of A-frame signs also in our sign code. There's two different sizes, and they're depending on the message. Again, another issue. 3 feet by 4 feet, or for a smaller version, up to 6 square feet total. Now, the original intent on these was the smaller one was for, say, a real estate open house. But would it really matter in this situation if that real estate open house sign was 3 feet by 4 feet, or if it was a maximum of 6 square feet? This seems like one of those places where we might be able to do a little consolidation. I don't think that anybody's going to be too gravely injured by having a larger sign that says real estate open house when it's a situation where the city could get sued because we're regulating it differently because of what it says on it. These are also utilized for civic organizations, businesses that are in certain locations like on Pioneer Way, and the residential open houses that I mentioned. Now we have a group of signs that might be typically seen on a single-family residential lot. Now you might have a sign that says that your house is for sale or for rent, or you're supporting a particular political candidate, or you're identifying the contractors who are doing the addition onto your house or doing the new roof. Again, these are signs that can be described by their physical structure. If you have a plastic corrugated sign that sits on little metal stakes in your front yard, we can describe that. We don't have to say this is a political sign or this is a sign for your football player kid or whatever that is. We can just describe that sign, how many of them you can have there and when they can be there. Banners. We have a category for banners in a number of different locations: community events, real estate signs, political or free speech signs. Typically, that banner is going to be a maximum of 4 feet high and 30 feet long. That's a big sign. But the other question that comes up from that is, do we feel like we have a problem with too many signs in this community? And I think that our sign code as it is now is working. I don't think we have a problem. So if we were to allow signs like this, I don't think that we need to change things up too much. And that goes back to that original comment that we're not looking to make huge wholesale changes to our sign code. We're just looking at making the messaging or how we relay that different and to be more in compliance with what the current laws are requiring. Pole banners. These are signs that you might see in a shopping center. Generally going to be on private property, these type signs. In our code, we have two different sizes for them based on whether or not one's connected at the top or if they're connected at both the top and the bottom. This, to me, again, seems like a place where we might be able to consolidate a little bit. But that's going to be one of those things that we'll start fine-tuning as we get into the real nitty-gritty details of
Do you know-
the matrix.
Sorry.
Yeah, no.
For the pole banners, when it's talking about free-flying versus bracketed, do you know where that came into play? I mean, is it more aesthetically pleasing to have a smaller sign that's bracketed, or is it a safety issue, or?
I'm not entirely certain. Steve, you might have some insight into that.
Sorry, the free-flying one was in the code first, I believe. And then the bracketed one came into being when we were working on some additional signage for automobile dealerships, I think was really the genesis for that particular type of code. Or that particular type of sign, rather. Which therein points to some of the problems that Ray is talking about. Yeah.
Yep.
Thank you. One more question, sorry.
Go right
So when
ahead.
you're
Yeah.
you're talking about consolidating some of these things, would you propose that we just have a section for pole banners? Or would you still include the size and whether they're bracketed or free flowing? I mean, how much do you consolidate something like that?
You know, if it were entirely up to me, I would say that we have pole banners and they are this size, and you don't make a distinction between how it is that they're held on, whether they have the two brackets or the one bracket. My only thing would be with that is that it be maintained, so that it's not getting shredded if it's free flowing, things like that. And these are things that we would include for every sign, that it's well maintained, that it's not falling apart, that it's not a safety hazard, et cetera. And so that's how you cover that, in my mind at least, is you say, well, you have a 3 foot by 7 foot envelope in which you can put either a free flowing banner or a bracketed one.
Now, when you're dictating the sizes, can you do something that, have a pole banner not to exceed 3 by 7 feet, and then there's still some more options if people want a smaller, or
Right, yeah, it doesn't have to be that big. That's the maximum. There would
Yeah.
be a maximum size. And maybe it would be, if you have a pole that doesn't allow for more than this much clearance, that you have to at least have that much, however much clearance it is. And I believe it's 8 feet in our code, to, safety, so
Yep.
people don't run into it, things like that. So, yeah, I mean, there would be a little bit of flexibility within that, but there would be a maximum. And there would be a maximum for all these signs. They don't have to be that big, but,
thank you.
yeah. So continuing on with the concept of the form-based sign code, not all sign regulations are going to be able to be neatly categorized with these lovely pictures here, right? So some things we're going to have to say in text. There's going to be standards for all signs. Like I talked about, that those signs be maintained in a professional and in a manner that's not going to cause problems for neighbors blowing over, things like that. No obscene messages. That's pretty well established. The maintenance of the signs, locations that do not cause safety issues or nuisances, permits and fees, administration, enforcement, and future nonconformance, and then definitions. So there will be still text within this code. It's not going to be just all in a magical matrix that has pictures in it. So that is important to note as well. So the ultimate goal of the new sign regulations, we went over this last time, so I won't go through that again, but ultimately is to create a new sign code that meets the compliance with Reed versus Gilbert, and then doesn't create any new non-conforming signs. We don't want to have a situation where we're going to have a bunch of illegal signs that we're going to have to worry about either amortizing through a period of time or getting rid of or what have you. We don't want to have an enforcement nightmare just because we wanted to go in and make it a little bit easier to figure out the sign code.
Ray,
Yeah.
Is there still a regulation, temporary signs, where that has to be on location? You can't advertise your business on someone else's property. Is that still in play?
Yes, Mr. Wassinger, what you're talking about is essentially a prohibition on off-premises signage. And that's a pretty critical one, but it's usually more critical for us when we're talking about the permanent signage, because off-premise signage is really a fancy name for a billboard. And so that becomes more of an issue. I think that there is some flexibility and some latitude for us to think about how we want to handle, as a community, off-premise signage of a temporary nature. And maybe it's more important to limit the number of them than location. This is something that we've talked a little bit about at the staff, but I also think that you could just as easily continue the prohibition on that and say that temporary signs should only be on the property for the service which is being offered. The challenging part of that is for the civic events, right? And those things that make our community a large part of what it is, whether it's a car show or some sort of fruit sale or this or that. We want to advertise those things. We want that message to get out there to the public. And so maybe it's too limiting to say that you can only put the car show sign on Windjammer Park, because how do you advertise for the car show otherwise? So I think we've got some work to do in that area.
So it can't be limited to brick and mortar businesses per se.
We could. I mean, you certainly could. I mean, you could
Or you
make,
could ban it altogether.
you
if
could
chose
ban them
to.
all together. I mean,
That,
there's a
something-
whole range of things here. I think we would be getting into uncharted territory for our community to think about having an A-frame sign for a business and having that sign put on a piece of property 3 blocks away. That would be brand new for our community to say somebody could advertise for a restaurant by putting their sign in front of your store. That's a tough thing to do.
We've been doing that with A-frame signs in the city right-of-way for businesses that are located more than a block away.
Does not mean that they've been done consistent with the code. And so we'll go back to something that I think we've talked about before, which is that from a code enforcement perspective, the city responds on a complaint-only basis. So unless that sign was placed in the middle of the sidewalk or in a place where it blocked visibility or prevented ADA access to something, the city would not proactively move that sign or tell that business owner that he or she couldn't have that sign there. If somebody called and complained and said, hey, business ABC has their sign here and they're down here, then we would have to respond to that complaint.
Is there a time recently when that has happened or we've had to go out and enforce any part of the sign code?
Oh, gosh, yes. We have not done much of it lately because of the Reed v. Gilbert, right? Because we don't want to be enforcing aspects of the code which have some constitutional questions associated with them. But there certainly was a time when we responded to complaints relative to signs, and we'd have to go out and help inform that business person what they could or could not do.
Also, Ray, those banners that are like pretty much ground level, that stand up maybe 7-8 feet, like in the Safeway, or excuse me, Hagen's now, they have some. And then, of course, the cannabis location has those.
Yeah.
Where do those fall into the
I didn't
mix of things?
I didn't do a picture of those because they're not, I don't believe they're specifically addressed in our code, but that's something that we can include in there because they're very popular.
They are.
Okay.
But,
And tube dudes too.
and
I think
I'm
that's what he
going
was doing.
to, that's me.
Yeah, those two, yeah.
I'm going to sort of play into Hal's hands here for just a moment, but those signs, those feather banners, I think they refer to in our code, technically only allowed within the central business district. As you can see, their use has slightly expanded outside of the business district. Yeah.
The question I got with that there, or the comment I got with that there is, if we're seeing things that's quote unquote, that's not being done and consistent with the regulations that we have, and here we are getting ready to do a major change to our sign laws, then shouldn't we be looking at setting up regulations to where we get less of that? So if we're going to have signs off the event, and we don't have that now, well, shouldn't we be looking at doing that so that way, we save people from getting in trouble like that? So that, it's a consistent all the way around. I hate to say if laws are being broken, and we can sit there and make it where everybody comply with them laws better by getting rid of some of them laws, then shouldn't we be looking at it that way there?
Would you like me to answer that, Ray?
I was going to say, that sounds like kind of a philosophical thing. Is it broken? Is what we have, is it broken? Do we need to fix it?
Yeah.
Go ahead and expand.
And so, from a technical perspective, we actually, our present temporary sign code allows some of those civic nonprofit signs to be located off the premise of where that thing is taking place. So that part is actually code consistent. But I understand your broader point, which is, should we be looking at the problems that we have as we think to the future to try to figure out how do we structure a code to eliminate some of those problems? I think that's a great idea. I think the other part that the staff level that we've talked about is this presents a great opportunity to reset the benchmark, right? So we've understandably had to have taken a hands-off approach here lately. As we go through this public process and as we begin the stakeholder process and talking with businesses and the chamber and the sign companies and everybody else, it's our goal to raise some community awareness of this new code that we're going to end up with, and use that as an opportunity to say, okay, here's how these rules can work for you, and then here are the things that you really can't be doing. And so, for lack of a better phrase, somewhat of a sign amnesty will take place, right? And we can start all over again. Right. Yeah, but I like your idea that let's look at the things which are causing us problems right now and see if we can figure out, with the community's help, is that thing okay, right? That the thing that's not entirely consistent with the code, and if it is, how do we work to make it consistent with the code?
Thank you.
Yeah.
And I think that will be one of the benefits of having a matrix, is you'll be able to look down, see that, maybe we don't allow that type of sign, so maybe we allow one. Or we allow five of these types of signs, and we think that's too many. It's all laid out right there in the easy-to-read manner. So I think that will help a lot, too. When we get to that point of installing everything into the matrix, we can take a look at it, find out what numbers look good, kind of play devil's advocate, figure out what might, cause problems if we allow too much over here and not enough over here. And then we can adjust those numbers and then come up with a final product. Yeah. So, for discussion, we've had a good discussion here. The questions being here, have we missed anything? Number one, I think you brought up the feather signs or feather flags or whatever they call those things. And number two, is there a problem that needs fixing with regards to temporary signs in Oak Harbor, or are the existing sign regulations working well? And so those are a couple of things to think about as we move forward. I welcome any comments from you as far as, if you want to send me an email or talk to me on the phone or stop by, what have you. We'll be developing this as we go along. So this is obviously still a work in progress. Nothing's been set in stone even close at this point. So that's where we're at now. For the next steps, I'm going to start drafting a temporary sign matrix, and inserting those specific dimensions, numbers, locational requirements, things like that, so we can have that to look at and make sure it looks good. Review the existing permanent sign regulations and developing those sign types. So next time I come back and show you pictures, those will be the permanent signs. We can discuss those. and then engaging the community stakeholders, getting everybody together and discussing what it is that we're proposing here, like Steve was saying, and making sure it looks good to everybody, and we're not causing too many problems by trying to fix something that may or may not be broken. So that's kind of where we're at right now. I welcome any further commentary or questions.
I have another question about temporary signs and
Yeah.
placement. My understanding is that an easement, city or state highway easement or county, that anyone can put a sign in there without permission? Is that or is that not true?
That's another Steve question, unfortunately. I'm not well enough versed in the details on
I
that.
believe that applies, Mr. Wassinger, to political signs.
Yeah, there you go.
It does not, and again, here we go with the
Political, that means they're content-based.
with their designation. So we're going to have to straighten that aspect of it out. One of the things which I still find confusing after all of these years, and I have to go back and sort of really look at things again, is that there are some unique regulations which apply to the state right-of-way from the state's perspective. I don't know how that works in this new sign code reality that we are faced with right now. And so I think that's one thing that at the staff side we'll have to do a little more work on to make sure that we understand fully what the state thinks is or is not appropriate within their right-of-way.
But you see, my dilemma is if we do sign-based corrugated sign, that could have anything on it. And if that's allowed in the highway, then anybody could put anything anywhere, basically.
It's an excellent concern, and this is where it's really going to be challenging for us and for the commission and the council to balance all of these interests, right? We've got to be squared away with the Constitution, obviously. We have to figure out what's the right level of signage for our community. But we have to be aware that when we move away from a political sign versus a temporary special event sign, by definition, things are going to get a little more generalized. And so you said it earlier, I think, we don't have to allow temporary signs, and that's always an option. But we also have to recognize what does that step mean for the community. If we say that's the best way to handle things, that means no temporary signs, or no temporary signs of a particular construction type.
And
So
there-
we can solve a problem, but you might create another problem as well.
There are the three categories of things that we can regulate: time, place, and manner. So if we regulate time, that's also a way that you might be able to kind of rein in any potential, avalanche of temporary signs that might occur. So that's a possibility as well.
But the thing that you also mentioned was that you're talking about the number of signs. So if it's a quote-unquote political sign, corrugated sign, whatever, I mean, if you limit it to 5 signs, then that's all that's supposed to be out there. I mean, obviously, there's going to be more. We all
Right.
know that. But, I mean, so there's got to be some kind of common sense laid out there. But, you're still going to be based upon the number of signs that can be out there.
Yep. The problem is who came first. That's the key. Yeah.
So one of my questions relates to limiting the number of temporary signs on residential parcels. I mean, if I
Sure.
look around currently in town, with our political season going on, there are many, many homes that are out of compliance. If we looked at this new matrix, there's people that may have 5 or 6 signs in their front yard that have been there for a year or 6 months, and we're saying we're going to limit them to 2 for 30 days. Are we going to be creating a code that encourages compliance? Or?
As a note, that is just.
Well, I understand this
yeah,
was conceptual.
Okay, conceptual.
But as we
yes.
look at this and when we look at what is actually going on in the community,
Right.
and I heard you say that you don't think that anything is broken, that it's working, that we don't have too many signs, and I would agree. I don't think there's a big problem. But if we limit it to what this conceptual matrix says, we are forcing people out of compliance to the way they're already existing.
And we don't want to do that. And the thing about it is, too, is this is going to be partly an educational process. if somebody wants to have a political sign or any kind of sign up in their yard for a year, is that a problem? And that's the question, the philosophical question that we need to answer as a group. Is that really a problem, or is it just a problem if they're your next door neighbor? That kind of thing. And if it's a 2 square foot sign or a 4 square foot sign, is that a problem versus if it's a 32 square foot sign? So these are challenges, and this is how we're gonna have to balance things out: is the time period, versus allowing people to have that freedom of expression that everybody has the right. So it's going to be a challenge to kind of balance those, and that's what we'll be working towards. Right?
I think one nice piece that you've added is the maintenance of those signs, because maybe it's not in particular the sign, but it's the distress of the sign or the condition of the sign that's really, causing an issue.
Right.
So
Yeah.
I think going at it that way kind of balances it out.
Yeah, because temporary signs, in
Right.
quotations, are not intended to last for years and years and years. They're going to start to look ragged after a little while, and if that's the case and your neighbor has 3 of them and the maximum number is 3, well, maybe they need to fix them up or clean them up or whatever it is they need to do to get 'em into compliance with that maintenance provision.
So if a temporary sign is defined by what type of a sign it is,
Mhm.
for example, an A-frame sign, but the message on it changes, for example, a restaurant menu board might change.
Sure.
But it's essentially out 365 days a year, 24 hours a day. It's no longer a temporary sign, is it?
If it's out 24 hours a day, it's not. Our current code allows for it to be out during business hours. And that's, I think, the temporary portion of that for an A-frame sign.
Wow. I bet if you drive down Pioneer Way right now, you'll see some signs out there, and
Yeah.
all the businesses are
There are, but
closed.
oftentimes you'll see the shop owners going out and picking them up as they're closing up for the day.
Some of the shop owners do,
You do
yeah.
see that.
Yeah.
Um,
Again, that goes back to the educational process, though, is maybe if that's a problem, we just need to say, look, you can have this sign out here
Yeah.
while you're open. This can't just stay out here all the time.
My only comment, you don't want to write an ordinance that's going to be an enforcement nightmare.
No.
So are we talking about doing some neighborhood work with the business owners and things like that to bring them into the fold, saying state law or federal law has now changed, so therefore we're having to amend our sections and we want you to be informed? I think that's a way to solve maybe an issue that's already existing, but also to bring them into the fold with what we're proposing.
Absolutely. Yeah.
Because enforcement of sign codes, that's a tough business.
I did code enforcement for a while. There's
Yeah.
no winners there.
Yeah.
Yeah.
So if I could chime in, I think I think in any planning process, it's important to have public participation. I think that's a part of, it's sort of a 3-sided figure, right? We have the policymakers or the policy advisors, you have staff, but you absolutely need the public to weigh in on codes that affect their businesses, their properties, their homes, their community. I can't think of any better example than something like the sign code, where our efforts will be very strong to try to engage the public. Because, we have varying opinions just with the 6 members who are sitting here. And probably if we were to grab 10 people off the street, we'd probably get, at least 5 different opinions as to whether we have the right number of signs. Are they too big? Are they too small? Are they the wrong spot? Is they just right? Do we not have enough signs, right? So, to me, this is one of those areas where trying to get as much input and public participation in this so that we don't end up with a code that is contrary to what the community wants, that we don't end up with one that's an enforcement nightmare, that has unintended consequences for businesses, and that still has confusion as to whether something is permanent or temporary. It's a rather large task ahead of us, which is why no planner ever really wants to work on the sign code, but we're sort of forced to do it from time to time. This is one of those times where I think we're going to work very hard to try to get you public input.
One other challenge I see when looking at the matrix is that we're limiting number of signs per parcel. And I have a kind of a problem with that when we look at varying shapes and sizes of parcels. We may have one parcel that has 50 feet of highway frontage and another parcel that may have 300 feet of highway frontage. And how do we tackle that at a code level to say, if you have 300 feet of highway frontage, can you not have a sign every 30 or 40 feet along the highway? When if you were driving through any other part of town where parcels were 50 or 100 feet wide, there could be the same number of signs.
Sure.
I see that being a challenge within the matrix presented, and not sure how to tackle that.
Yeah, and that could be one of those things that needs to be text described in some way. Because I know exactly what you're saying as far as, if you have a shopping center that they kept it all in one parcel versus a shopping center that has a bunch of pads on it that have frontage, that's kind of a inherent unfairness between the two. So there's definitely going to need to be some real thought into that, for sure.
You also want to balance, though, the temporary versus the permanent signage, right? So
Yeah.
keep in
Correct.
mind, we're only talking about the temporary signs. So 50 feet versus 300 feet, let's just, for the sake of conversation and make it simple for us, it still only has one business on it. Should the one business that has 300 feet have three times more A-frame signs along the sidewalk advertising their particular business as opposed to the one that has, or 6 times more, as opposed to the one that just has 50 feet? I don't know what the answer to that is, but frontage might work best when we talk about permanent signage because we do have different allowances for how much frontage you have. I just don't know.
Sure. And I can see this going in places that are not developed as well. There are several parcels that are prime for community event sign placement that are undeveloped, and they have multiple signs at any given point. But it would be a limiting factor on those privately owned parcels. And I think it would greatly impact the civic community as well.
Sure. All right. Thank you, everybody.
Steve, would it be appropriate to ask the audience if they have any input?
Absolutely.
I know, Harry, would you like to comment or have questions or?
I'm Harry Turner, and I'm representing the Kiwanis Club. I'm also the organizer for the Beachcombers Bazaar every July. And signage, according to the feedback we get from our participants, is always inadequate. You don't have enough signs out. There's not enough instructions how to get here. Why don't you advertise over in Skagit or Bellingham? And it tends to mushroom. That's one aspect. The other aspect, and I understand Steve's comment about enforcement is on complaint. We've been putting our signs out a month ahead, and yet I see the fruit sign, a temporary sign, is out a month or so before they start. Or sometimes in the past, we've had the car signs out 2.5 months before the event. I hate to complain because that's another nonprofit community service organization. So those are the two big things that I see. Looking at the proposals and all like that of signage, I think we can work with that. I definitely don't like the idea of 2 signs maximum on the property event. If I put 2 signs down on Windjammer Park, nobody's going to know anything's going on. And that's just a geographic problem. So I would not recommend saying it has to be on the property because of the geography of our city parks. And that's pretty much it.
Thank you, Harry, for your input.
I would say that particular situation would be something that we could pretty easily fix, if you will, without having to be content-based. You say, for instance, in one section of the matrix where it talks about the the different land use categories or different zone districts, you say for an open space zone district, parks, that if there's an event going on, then they're allowed X number of signs. And we work within the context of what's traditionally happened in the past. I don't think anybody's complaining about signs for the Beachcombers Bazaar or the car show or anything like that. So I think it would be fairly easy to work that in to what we're proposing without being content-based at all.
Well, and I think that the way that this matrix looks to me, I think it kind of fixes that inherent problem that we had. I've worked with Harry a lot on the Beachcombers Bazaar, and that was one thing that we always felt hamstrung by, was we came and asked what we were allowed to do.
Yeah.
And I think a lot of other groups have not done that. So when we were in compliance, we felt like we were handcuffed on what we could do. But the way that I see this progressing is that if we had private property owners with prime locations, they could allow us to use their one sign that they're allowed on their parcel to advertise our event, if we're not limiting those organizations to only having 2 signs or something along those lines. Sure. So I think it could inherently work itself out, going away from the content base.
Okay. Any comments? Thank you, Ray, for your work and work in progress. I believe we'll get there. And it may be better than it was in the past as far as getting rid of the content. Okay, so the next item. Item B on the public meeting side is annual comprehensive plan amendments. This is a public meeting, and Jack Mack will walk us through this.
Good evening, Jack Mack, Senior Planner. This is my usual pitch during this time of the year for our annual comp plan amendments. We missed it last year because we did the major update to the comprehensive plan, so we had a lot of work to do there, and you can amend the comprehensive plan only once a year, and that was going to be our amendment in June when we adopted the major amendment. So this year we're back to the cycle. We've already advertised a couple times for to the general public if they have any suggestions, or if usually we get some rezoning applications, which we're hoping this time we'll get less, because if you remember, we changed our land use map from a 1-to-1 kind of a ratio to a generalized land use map. And so if people want to change their zoning, if it's close enough and they fall within that same land use category, they can go through a straight rezoning process without having to do a comprehensive plan amendment. So we're not hoping to get too many applications, but the deadline is December 1st. So we still have some time. But I haven't gotten any calls, neither have I heard anybody else getting any calls about it, so I doubt we'll get any sponsored applications. However, we do have some agendas, some docket items moving forward for next year. We have, of course, the capital improvements plan, which we almost amend every year. Some years we haven't amended them because there were just absolutely no changes. We're not anticipating any changes in 2017. However, with the adoption of the budget, which is going to happen next month, we could see if there are any tweaks that need to be made to the capital improvements plan. So we have that on the docket if we need to. We also have an update to the economic development element, and this is something that the mayor's office is making an effort on, and we want to kind of keep the door open if they do have some policies and things that they want to change as part of their effort, then we can include that as well in the amendment cycle. One of the bigger items that we'll have for next year is the Parks, Recreation, and Open Space Plan. That needs to be updated in order for us to be compliant for state grants and so on. So that'll be a major effort that we'll start working on next year. And again, sponsored amendments, if we get any by December, we'll include those as well. So the schedule usually works. We put the docket together in December. We bring it to the Planning Commission, present it in January, The Planning Commission will forward it to the City Council. City Council will take action on it in March, and then we start working on those amendments, and then come back to amend the comprehensive plan in December. So pretty straightforward stuff. So any questions, I'll be happy to answer.
I just have one quick question. Prior to the generalized land use map, how many of those sponsored amendments were coming in? I mean, did we have any last year or the year before?
We had one not in 2015, not for the 2016 cycle because we didn't do one, but we almost had one every year, and in some years we may have had two.
Okay.
They were minor, but at least we had, on an average, one application.
I just think that was a nice change.
Yeah, and I think we probably will have, I've already got some questions for rezoning property, and we need to tweak our language on rezoning in our zoning code, which I'll be coming forward in January to present to you guys, to just kind of make it a little more streamlined with how we did the land use amendments. The current language is based on how the one-to-one ratio works, and so it's a little pretty extensive in terms of requirements for rezoning. And I think we can make it a pretty a simpler process. And so we'll probably need to tweak the language there to do that. And so we'll come in January to do that.
And then one more question. When we look at the Parks, Recreation, and Open Space Plan and being compliant for our grants, does that tie into the Windjammer Park Improvement Plan, kind of looking at that project long-term for grants?
I was told that we did inquire whether our Windjammer Park integration plan was in compliance, and we were told yes. So if you wanted to apply for grants for that particular section, we can based on that plan.
Okay.
But the Parks, Recreation,
This
and
would
Open
cover
Space
all
will
the
cover all
others.
of it, and so
Yeah.
we can apply for more grants that cover other projects as well.
Thank you.
So.
Any other questions, comments, commissioners?
All right. Thank you.
Thank you, Pat. A reminder that our next regular meeting will be December 13, 2016. And if there's nothing else for the good of the order, I call the meeting adjourned.